Hey, good morning. John Strohmeyer with Strohmeyer Law. This morning we are going to be talking about what you need to know about trusts. So we're going to get into some of the basics on what happens with trusts, what you should be thinking about. If you've got questions, go ahead and drop them in the chat. I'll be looking at that as we go along, and we will be running through a number of things. Why trusts end up confusing a lot of people, and they are not readily obvious. There are a lot of misconceptions about what a trust can and cannot do for you, and even when you need to use a trust. So it looks like there are a few things coming in. All right, well, let's start. A lot of things that come up are, well, do I even need a trust? The answer is maybe. And we want to start by thinking about what types of trusts are there. There are two broad categories that we think about when we think about trusts. The first type of trust, a revocable trust. This is something where somebody sets up a trust, and the person who sets it up, that can be called a donor, a grantor, or a settlor. The terms all basically mean the same thing, but this person, the person who's putting stuff into trust, if it is a revocable trust, then that trust can be revoked, and the donor can bring back all of the assets to themselves. On the other hand, there are irrevocable trusts. The person who is putting assets into the trust, the donor, can't bring it back. Once they are putting that into trust, then it is gone. They can't pull it back. So when we're setting up these irrevocable trusts, we want to make sure that we are clear on what's going to happen and why we're going to do things. We're basically, I'd like to explain this to clients, when we're putting assets in an irrevocable trust, we are putting those assets into a boat, we are pushing it out to sea, and we are waving goodbye to them. Those things are gone. They're going to go live their life on a trust, and we're not going to get them back. So when we think about it, again, first division is going to be between a revocable trust where you can pull it back and an irrevocable trust where you cannot. It is going into trust. It is not going to come back. You want to make sure you know what you're doing. We're going to further divide the irrevocable trusts into two types. One, lifetime or inter vivos trusts, and on the second hand, testamentary trust. Inter vivos trust, these are trusts that you set up while you're still alive. The grantor is going to put assets into a trust. It is going to be irrevocable, and then once they do that, they're doing that during their lifetime. This trust will probably go on beyond the grantor's lifetime. They're going to make sure that they're transferring assets. Normally, we are setting these things up for tax-motivated reasons. We want to do some estate and gift tax planning with those assets. That's why we're putting it in trust. But that's not the only reason why. We can also be putting things in trust in these to protect them from either yourself, protect the beneficiary who is going to benefit from ownership of these assets. We want to do something, we're putting them in trust for some reason. On the other hand, those testamentary trusts, these are things that get set up after somebody has died. So once you put assets in trust, is it when the donor is alive? It's going to be an inter vivos trust. If it's when the donor has died, then generally that's going to be a testamentary trust. It's going to go into trust when, under the terms of a revocable trust agreement, or it's going to be under a last will. The idea is you've got control of these assets until you pass, but then once you die, we're going to transfer the assets into an irrevocable trust that then goes on for longer term. So these irrevocable testamentary trusts, again, they can be set up under a last will. They can be set up under a revocable management trust that when the donor dies, the revocable trust becomes irrevocable. The provisions are there. It's not going to be able to be changed anymore because the donor has passed. So at that point, we're looking at how do we make sure that the trust agreement is in place. So again, going back to the start, Donor, grantor, settlor is the person who's putting assets in trust. They're putting assets in trust for the benefit of a beneficiary, generally one person. You can have multiple people. If it's an individual trust, it's generally easier because the trustee is only responsible for managing and dealing with a relationship with one beneficiary. You can have multiple beneficiaries, whether it's a group of siblings who are all benefiting from that trust. You could also have one primary beneficiary, and then that primary beneficiary's children can also receive distributions. When we're thinking about that, when we have more than one beneficiary, something we call a pot trust. The pot trust there owns the assets for the beneficiaries. It's not any one person, it's not an individual trust. And so again, that's something where it doesn't matter if it's lifetime, testamentary, revocable, irrevocable, different provisions we can add to this. So why are we looking at trusts? When people call up, they're generally going to be asking, hey, we want to set up a trust. Do we need a trust? We've talked about 3 different broad types of trust that we may be thinking about. And so there's not a quick answer of, well, yes, you need one of these, because we have 3 different types of trusts. So let's think about this. When a client calls up and says, do I need a trust? We need to walk through why are they thinking about this. If we're thinking about the irrevocable lifetime gifting trust, this is for somebody who is primarily thinking about taking assets off the table for estate and gift tax purposes. We're not going to get into the calculations, numbers of why you do that, but generally you're worried about paying estate tax somewhere down the line, so you want to take assets out of your future gross estate for estate tax purposes. We want to make sure that you're not paying too much tax later on. Most people, good news and bad news, we're not worried about paying estate tax, and so most people don't need that lifetime gifting trust. Other reasons that are not tax motivated for this, you want to own an asset and you want to make sure that the beneficiary is able to benefit from that. You're worried potentially about the beneficiary mismanaging those assets. You're worried about the beneficiary's creditors, or perhaps even predators, future ex-spouses, somebody who could come and take those assets from them. You want to put them into trust so that the beneficiary has the benefit of those assets, but they're not directly owning them. Why? The benefit of all of this is that when it's owned in a trust, you're separating legal title of who owns the property from the beneficial ownership of it. And so this is something where when you are a beneficiary of a trust, the trustee owns legal title to that. If somebody wants to deal with that asset, until the trustee has made a distribution to the beneficiary can't say that they own anything. It's up to the trustee to make that distribution. Now, we'll have later streams where we talk about what is owned and how do we deal with asset protection. But for right now, this is what we're doing to make sure that things are available to the beneficiary. The trustee is in charge. Type of trust number 2, an irrevocable testamentary trust. When do we set these up? Generally, we're setting these up when we're thinking about assets going to a beneficiary, and we want to protect them. Again, how much do we need to protect them from these creditors, predators, and future ex-spouses? Well, if they're under 18, you may not want them to own assets. You may not want to leave something to your underage minor child, because that person legally isn't allowed to own property. Why? They're a minor. So you want to set up that trust so that the trustee can own assets for their benefit. They can make distributions to them, basically own it until it's time for them to be able to access those assets. That's going to be the big reason. Now, we've got a lot of ability to look at this and say, okay, well, you're setting this trust up. How long does this trust need to last? With trust, you're always going to have the flexibility to think about, should it last, until you're age 18, distribute it watch the beneficiary send all of those assets off to the Maserati and Fabergé egg dealership? Do you want to hold on to it longer? Do we have other things that we want to think about? What distributions do you want to make to those beneficiaries? So those are things we think about when we're thinking about irrevocable testamentary trusts. Finally, the third type of trust people are usually asking about, can we set up a revocable management trust? Now, this usually is preceded by, hey, I want to avoid probate. Probate is not the end of the world. It is something that we think about. It is easier here in Texas than in probably almost any other state. We, can generally be in and out of probate in a couple months. We don't have mandatory fees for executors or the lawyers in terms of who is going to get paid. So a lot of the reason people don't like probate, or they think that they don't want to go through probate, is that they are, and they're watching movies and TV shows that are filmed in states that do have onerous probate. So Florida, California, New York. These are states where just about everybody sets up revocable management trusts to transfer all of their assets to manage things beyond their control. Revocable management trusts we also think about for people who were worried about dementia, Parkinson's, Alzheimer's, something where there's a chance that that person may need a guardianship for themselves. So we're worried about them losing the capacity to manage their assets, and we want somebody to be able to step in. So again, thinking about this, again, all in context, three types of trusts: revocable management trusts, which we use to manage assets at lifetime. It also can direct the distribution of assets after you die. Irrevocable testamentary trusts. This is what a lot of people are thinking about because it's a way of managing assets after you die for the benefit of your beneficiaries. If you're worried they can't manage the assets correctly, or they may be exposing those assets to future costs, creditors or predators, future ex-spouses. Finally, lifetime inter vivos irrevocable gifting trusts. We're generally making these trusts, we're creating these trusts so that we can transfer assets and have them managed normally for tax purposes, but not always. Just kind of depends on what's going on. So that's a lot of what we're thinking about with that. Looking at some of the comments or questions that we've got. So the value of a trust is that it permits someone the benefit of a particular asset without having legal title to that asset. Yes, the primary feature, one of the reasons that trusts were created, is that when you are setting up a trust, it is a relationship between the donor, the trustee, and the beneficiary around a piece of property. A trust is not a legal entity. It is not like a limited liability company or a corporation where you go to the Secretary of State and pay a filing fee, set up some forms, and presto chango, you have a new new state recognized entity. A trust is a relationship, and so this is the relationship between the trustee, the property, and that beneficiary, with the donor making the transfer into the trust. What this means, you're going to have some options on when and how that relationship is created. You're going to think about, well, when do those distributions come out? When should the beneficiary have access to assets? Do you want to make it completely in the trustee's discretion to make distributions? Can the beneficiary go in and just pull out whatever they want whenever they want? When we think about a revocable management trust, because it's revocable, it doesn't matter what the distribution standard is. The beneficiary, who is generally going to be the donor, they're going to be able to revoke the trust. They can pull anything out. They can almost do whatever they want with that trust. Now, sometimes we'll set up revocable management trusts for the benefit of somebody else, where we're going to own assets. We're not necessarily looking to move assets out for tax reasons, but we do want to start separating title, providing that assets are governed in a different way now as a way of just managing that asset. So another question, revocable trust for avoiding guardianship. How does that revocable trust avoid guardianship? When you go into a guardianship, and so Once you pass age 18, you are emancipated, you become your own adult. You are able to make your own decisions about feeding, clothing, and sheltering, as well as managing your own assets. You are free to make all of the bad decisions you want. Nobody can stop you. This also means when something needs to be stepped in, if you start making bad decisions because you are losing capacity, and this can happen for any number of reasons, when that starts happening, that's where the guardianship process here in Texas steps in. You can have two types of guardian. The revocable management trust only addresses one type of guardianship. So the type it does not address, guardianship of the person. This is somebody who is appointed to make feeding, clothing, sheltering decisions for the benefit of the ward. And so if you are a parent of a minor child, you are automatically the natural legal guardian of your minor child. Once they turn 18, they don't have a guardian anymore. At that point, they can make their own feeding, clothing, sheltering decisions. But while that minor is under 18, they don't have a default or natural legal guardian of their estate. Why? They're not allowed to own property. If somebody does transfer property to them, we then have to set up the guardianship for them to make sure that we know who is in charge of this minor's property. So a guardian of the estate is what we're thinking about with the revocable management trust. That trustee owns assets and is able to manage them for the benefit of the beneficiary. When you go to a guardianship of the estate, one of the prerequisites before you can set up that guardianship of the estate is that the probate court has to make a finding that there are no less restrictive alternatives to a guardianship. Guardianship is a big deal. It requires a lot of court filings, going to court, dealing with things, keeping better records. Why? You've taken away somebody's rights to manage either their person or their estate. So what we're thinking about is the court doesn't want to get involved. The idea is to tailor as much of that guardianship as possible to the specific circumstances to keep it as least restrictive as possible. This is a feature, not a bug. And if there is a way to avoid setting up a guardianship, the probate courts are going to look for that. So how do we do this? We start thinking about things like, powers of attorney allow somebody else to make decisions for you, whether it's a financial power of attorney or statutory durable power of attorney. This allows somebody to name an agent who can make decisions for them. Your medical powers of attorney and living wills allow you to make choices for yourself before you lose capacity, so somebody else can make those decisions for you. What we think about then is having this revocable trust is another tool that's going to be less restrictive than setting up a full-on guardianship. And that full-on guardianship is, kind of the most restrictive option. If we have the trustee set up, we have powers of attorney where we set up a revocable trust, even if we don't fund assets or transfer assets into the trust, the agent under the power of attorney can transfer assets into the trust, so the assets are subject to the trustee and not subject to the guardianship. The guardianship of the estate, then, that guardian ends up taking over and managing any assets that are not already being managed by someone else. And so again, the primary way to get around this is having assets in a trust for the benefit of that person. If they're managed in a trust, then the ward under that guardianship didn't have title to it. A guardian who is appointed can't take over and necessarily take assets back. What's the limit on how much of my assets I can put in trust for my children? So this is going to get into more of a question of tax and whether or not you're going to be subject to tax for putting assets in. This is, ultimately you can put as much as you want into a trust, whether it's irrevocable testamentary, lifetime irrevocable, or revocable management. There's no state imposed limit of you can't put more than, $1 million, $10 million, $50 million, $50, whatever it is. There's not an upper limit based on state law on what can go in there. There are tax consequences to this. We're not going to get into tax consequences too deeply today because that is its own live stream on this sort of thing. We talked a little bit about asset protection. Again, broadly speaking, what misconceptions on this? If you set up a trust for yourself, so generally this is going to be you're setting up a revocable management trust for your own benefit, you're going to get zero asset protection in Texas for this. And this is what is known as a self-settled trust. You're setting it for settling the trust, you're putting assets in trust for your own benefit. You're not going to be able to protect it from your creditors. This is a feature of Texas law. Texas allows you to set aside a lot of assets for asset protection. There are generous protections for retirement accounts, life insurance policies, annuities, your homestead, certain amount of property. This is protected from creditors because Texas doesn't want you to Texas basically doesn't want you to be on their dime. Texas is a low service state, low taxes, low service. It's a choice. And as a result, they protect what people own to a great extent. But there are limits. And so if you're worried about lawsuits, creditors, things like that, people coming and taking your assets, asset protection is something that you can do. There are legal ways to do it. We'll talk about that in a different stream. But protecting assets by putting them in a trust for your benefit generally will have zero effect. When do we want to think about some of the taxes? Two big things to think about in taxes. One, income tax. What are the income tax consequences of this? Who is going to pay tax on the assets that are held in the trust? Two broad options. One, the trustee is a separate taxpayer from the donor and the beneficiary. They're going to have their own income tax return every year. And because they're going to pay income tax at their own trust rate. The other option is somebody other than the trustee is treated as the taxpayer. This is known as a grantor trust. So the income, instead of being taxed to the trustee, is taxed to somebody who is not the trustee. Many times this is the person who set up the trust, so that's what it's indicating. The grantor, the donor, the settlor of the trust is the one who is taxed on that income. There are ways of making the beneficiary subject to all the income tax that is generated within the trust. Again, getting beyond that, getting too deep into that is more than we're going to do today. The other set of taxes we want to think about, estate and gift taxes. Estate tax, taxing what you own when you die. Gift tax, taxing what you have given away to somebody during your lifetime. There's a third tax, generation skipping transfer tax. We'll leave that one alone for now. When you put assets into trust, you may be triggering tax consequences for those. And this is where the limits of what you can put in trust will be set up. You're more than welcome to put $25 million in a trust. You just may end up paying some gift tax on that. Another question, what's the value in having a trust manage my assets if I'm a trustee and still making all the decisions? This gets to a revocable management trust. Why would you want one of these? You're really looking at, the big benefit in those painful probate states, California, New York, Florida, among others, is you're going to avoid probate later on. That's a good thing, kind of speeds up the process, avoids some costs and delays. Lifetime, the benefit is that it is going to really provide you with a method of avoiding guardianship of your estate, which can be costly and can delay and even hinder your own care and treatment. And so the benefit, there are a couple different benefits. Different people find different reasons of setting these up. Really does depend on your particular situation, what you're looking for. In terms of assets going into a management trust, well, when we look at the irrevocable trusts, so irrevocable testamentary and lifetime irrevocable trusts, we're generally going to be funding cash, brokerage accounts, stock, stuff that we're giving away. It may be, those types of trusts may be the beneficiary of 401ks, IRAs, they'll receive the assets after the person has died. That beneficiary designation is responsible for getting the assets into the trust. On a revocable management trust, we're putting the assets in there that the trustee should be managing and that a trust can own. This is real easy for bank accounts, for brokerage accounts. You may even put real property, business interests. So, if you own an LLC, putting that in the trust, you're going to do that while you're still alive. Things like 401ks and IRAs, generally we're not going to fund those into the trust during lifetime. Why? It's generally pretty hard for the custodians of those accounts. So you're thinking about Fidelity and whoever else may, when you say, oh, I'm going to go log into my account with so-and-so, those custodians have a hard time transferring title while somebody is alive. It's generally not worth it to do that. The other things that we don't want to put in a management trust are things that we don't think we're going to hold on to long term. We kind of have the backup of transferring assets under a power of attorney into that management trust, so we may not want to do that. But things like cars, we're generally not going to retitle unless you think you're going to hold on to it forever and you want to direct the distribution of it. So if you've got a classic car collection, you may end up retitling that in the name of a trust. But if this is your daily driver, it's a car you bought 3 years ago and you're probably going to sell in another 2 or 3 years, we're probably not going to do that just because it takes more headache to get it into the trust, go spend the $75 to have it retitled. You may, when you purchase a new car, take title in the name of the trust, but while you still have the trust, while you have that existing car, and if you just set up the trust, we may just skip over that. What is an insurance trust? So this gets to what does a trust own? Insurance trust, as the name indicates, these are trusts that own insurance policies. There are some very specific tax rules on those. We're not going to talk about those today, but really what you're getting at is those insurance trusts are meant to own life insurance. Generally, you're going to be thinking about how do we get this out of the donor's federal gross estate for estate tax purposes, because there are some tax consequences to owning life insurance policies. We don't want to trigger those. Last question, how do I make the trust the beneficiary of my life insurance and my IRA? So this is where the beneficiary designation forms for those IRA, life insurance, annuity, 401k, whatever, 403b, whatever those things are that have beneficiary designations, they generally all have a way of naming a trust as a beneficiary of the policy or the account. So it will depend based on who, where the account is held and what type of account it is. But the forms or logging, what we're finding more is in the last few years, you have fewer forms and more just logging into the account and setting things up there. When you do that, that's what's going to tell the custodian who owns the account, well, what happens to this account when the owner dies. This is where we get out of an asset that's subject to a will, because these accounts are subject to contracts. Your account with Fidelity, that IRA, it's basically a contract right. You're giving them your money, they're agreeing to hold it and manage it in a particular way for you, and then they're also agreeing that when you pass, they're going to transfer it to the people who it should be transferred to. So with that, we're going to go ahead and shut things down for today. This has been, a lot of things to think about when we start talking about trusts. There are a lot of questions and answers in here. We'll be talking more about this. Next time, we're going to be talking about asset protection. What does it look like? What can you actually do? How can you protect assets from your creditors? Thanks so much.